I just sent a note to Nate. I can't hear anything.
Oh, okay. Well, we just heard you, so you still can't hear us at all?
No, now I can hear you. Something just clicked in.
Oh, okay. Super. Well, we're doing roll call and we're up to you. So are you present, sir?
Knutson here.
Newton present. Ladd?
Present.
Ladd present. Larkin?
Present.
Larkin present. Middlebrook?
Present.
Middlebrook present. Moore?
Present.
Moore present. Morath?
Present.
Morath present. Schnell? Did we drop him?
Yeah, he's not showing up there now.
All right. Schnell is absent for the time being. He was on the call earlier, so perhaps he fell off. But
Is that his number is up there? Is that him?
no, that's us. That's
The 9521?
yeah. That I believe that's us. The 7730 is us. So I'm going to mark Schnell as absent for the time being, subject to change, and Chair Mitchell.
Here.
Chair Mitchell present. Madam Chair, there are 8 members present, 3 members absent.
All right, with that, we have a quorum. First item on the agenda. So the agenda actually has the first item, 2A and 2B are to approve the draft meeting agenda and the draft meeting minutes. I kind of like them being together because we have to do the roll call. So if you all have had time to review the minutes and if there's anyone who's willing to do a motion to approve them both at the same time, I would entertain that motion. But if anyone wants to split them out, we can do that as well.
Madam Chair, before we move on to that, can I just try? Can I just try promoting Officer Ibrahim? It appears to be
Oh, sure, absolutely.
a member of the public.
It's like Commissioner Schnell's there too.
Commissioner Schnell?
I'm present. Sorry, I got disconnected.
Oh, okay. So back to item number 1 with your permission,
Yes.
Madam Chair. Roll call, Officer Ibrahim?
I'm
Present? All right, Ibrahim present. Thank you. And then did I hear that Schnell was in the?
He is present. Thank
Yes.
you.
Oh, Schnell. Okay, roll call, Schnell?
Present.
Present. All right. Madam Chair, there are 10 members present, 1 member absent, and Member Hansi did just indicate that she was unable to make the meeting today.
Okay, all right, so we have a quorum.
We do.
All right, so moving on, do we have a motion for either approval of the agenda and the minutes or one or the other? Commissioner Middlebrook?
Thank you, Madam Chair. I will move to approve both the agenda and the draft minutes from the last meeting.
Great, any, do we have a second?
Last seconds.
Commissioner Ladd seconds. Do we have any discussion on either? Hearing none, if we could call the roll, Nate.
To the Middlebrook motion to approve the October agenda and the September minutes. Estrada?
Yes.
Estrada, yes. Hansi? Hansi absent. Ibrahim?
Yes.
Yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
and with that, the motion is approved unanimously. All right, item 3 on the agenda is the budget change requests. It's an action item. I'll turn it over to Nate.
Thank you, Madam Chair. We did discuss this at the last meeting. I'm not going to spend a lot of time on the materials that are duplicative of what we discussed at the last meeting. So we before we get to this particular agenda item though, this slide, the first slide here is just priorities for the meeting. So it's sort of an overview that you asked me to give the commission, Madam Chair, on what we're doing at this meeting. And this is hopefully to streamline our process because we do have a lot to cover this meeting. So the first is, you said this is an action item to act on the budget change items. That's because there's a deadline here. October 17th is the date that these are due to Minnesota Management and Budget. If there are to be any change items, I have to have them to MMB by October 17th. And while it's not necessarily required for the commission to approve the change items, the statute does require the commission to approve employee positions. And I would request that that I receive the commission's guidance on these change items. I think they're significant enough that it's appropriate that the commission provide its guidance to me in its role as the oversight body for the agency. The second priority for the October meeting is to discuss any sentencing guidelines amendments that are desired to take effect in 2023. And these would have to do with the comprehensive sex trafficking review and any action that the commission wishes to take on a custody status issue. These are agenda items 4 and 5. The reason why this has to be discussed at this meeting is because in order to meet time constraints, it has to be, final action has to be taken prior to January 15th, which means final action has to be taken at the January meeting. In advance of that, there has to be a public hearing. In advance of that, there has to be a motion to advance these proposals to a public hearing. And that has to happen in order to meet the time constraints for the public hearing at the November 3rd meeting. And under your meeting rules, the commission must discuss every proposal that's to be adopted at the November meeting at the September or October meeting. Or if not the proposal, at least a similar or prior version of it. So the action for this meeting is to discuss any guidelines amendments that the commission wishes to take effect in 2023. And the third priority for this meeting would be to direct staff to provide any new research that you need for the November meeting. So in advance of those decisions that you need to make in November, we would ask you to give clear direction to us so that we know how to spend the 4-week interim in doing research for you. For example, any impact statements, writing up any draft language, that sort of thing. So starting with the advancing sentencing policy and data for Minnesota, that's what we're calling the change item package for fiscal years 2024, 2025 and beyond. I'm going to go through these first several slides quickly because we did cover these at the last meeting. These are the same 4 proposed change items. The first one is to comprehensively review the sentencing guidelines. And that's certainly the one that takes the most slide. That's the one that had the most change, and that's really what I'm going to be focusing almost all our time today on. Not really any change, although I do have an update with respect to the second one. But not really any other change on the other 3. So comprehensive review on the sentencing guidelines. I don't think I changed this slide much. This is the background for the comprehensive review. Essentially, there hasn't been a comprehensive review since the commission established the sentencing guidelines in 1980. And we did recently hear from a couple of other states that have undergone comprehensive reviews. And that really spurred the thought that perhaps it's time for us to be doing a comprehensive review, particularly in light of the fact that the statute, the charter statute, now directs the primary consideration to be public safety for the sentencing guidelines whenever they're promulgated or amended. That was not part of the original charter. So it seems to me just sort of conceptually, if the commission is given an entirely new fundamental principle upon which it should base the sentencing guidelines, it would seem to me that would make sense to comprehensively review the sentencing guidelines in light of that new principle. These questions haven't changed. Again, public safety being at the center, but these are some examples of questions that the comprehensive review might answer. The timeline has changed, and this was based on the feedback that the commission gave me at the last meeting. Very useful. I went back and talked some more with Pennsylvania and Washington about how they did it and what resources were required and so forth. And the primary thing that I got out of it was really stakeholder engagement was enormously important to their processes, and they really outsourced their processes quite a bit. And part of the reason they outsourced that was for stakeholder engagement, but and candidly, we're not experts on stakeholder engagement, but we are. There is an entity within Minnesota Management and Budget called the Management Analysis and Development Division, or MAD. And MAD, they are experts at stakeholder engagement. This is what they do. So immediately after talking with Pennsylvania and Washington, I contacted MAD because it became clear to me that that's a blind spot that I had was really diving into stakeholder engagement and making that a primary element of at least the first phase. And another change in doing this is I came up with a timeline that's more defined here, which is on the next slide. And it became clear to me, talking with Matt about what their timeline would be for stakeholder engagement, that this would definitely be a 4-year project. So phase 1 would be gathering information for the first biennium, and then there would be an anticipated phase 2 extension with a cost to be determined and a scope to be determined. And I think it'll be clearer by the time we, 2 years from now, what phase 2 will need to look like. But the goal would still be to report to the legislature no later than January 15th, 2027. And I know there's some skepticism, and it's well justified skepticism, that we could reach the goal of doing this in 3.5 years, given the fact that it's taken Washington and Pennsylvania so much longer. I will say one is I am an optimist, so that doesn't always work well when it comes to meeting goals, because sometimes I am overly optimistic. But I also think that we can learn from the lessons of Pennsylvania and Washington and compress the time schedule quite a bit more. For example, some of these entities did a lot of stakeholder engagement in a consecutive manner. It did not have to be consecutive. They talked to this group, and then they'd say, oh, that was interesting, we should talk to this group. And then they say, okay, that was interesting, we should talk to this group. And by the time you're done with all that, it takes years. But what I'm picturing is that we identify the stakeholders. Well, I can talk about the cost of this, but I'll come back to the cost of this. So let me move on to the timeline slide. So and this is something that Commissioner Knudsen challenged us to do, is to come up with a timeline that the legislature is going to be expecting this. Pretty reasonable, and it was helpful, I think, in talking to MAD, and they're sort of on the top. They're reflected in darker gray. What they'll be doing, and they have a pretty clear idea of what the steps are for a stakeholder engagement process. The first step would be project planning, including stakeholder analysis. And I do have a representative from MAD who's I think participating in this meeting as a member of the public, who I could promote to a panelist if the commission does have questions, and that's acceptable to the chair. But I think it was helpful to get a sense of what the process was from her. She's a deputy director, Lisa Anderson, from MAD. But the first step would be project planning, possibly, and stakeholder analysis, depending on, and that would be where MAD and MSGC were working together. That possibly that would be something where there would be a subcommittee from MSGC to work on that. I know sometimes the commission is not a big fan of subcommittees, and it's a small enough group that it might be possible for the entire commission to work on this. But at any rate, MSGC and MAD would be working together on project planning, including stakeholder analysis. I will just say that brainstorming with Ms. Anderson, Deputy Director Anderson, and this was by no means a comprehensive list, but some of the groups that we came up with were judges, prosecutors, defense attorneys, members of the community in general, members of the community specifically, including crime victims, defendants who have been prosecuted, including prisoners who are currently in prison under the current sentencing guidelines. Those are the initial round of group, and with emphasis on some of those communities that are most acutely affected by, or at least most acutely represented in prison, as a proportion to the overall population. So those are some of the groups that we'd be looking at in the stakeholder analysis, and those would be identified in that first phase, July through September. Then the next 6 months would be the stakeholder data collection, which would include surveys. So surveys can include all members of a group, for example, the entire judiciary, focus groups, listening sessions. That would all be the work that MAD would be doing independently of the commission. So they'd be doing that on their own schedule with their own resources. And then 3 months after that, for the next 3 months after that, they'd be analyzing the data they collected and coming up with a report eventually and making recommendations from the report. And then that would be presented in the fall of 2024, which would be about the same time that the commission, would be needing to identify and request phase 2 resources. So we'd be 2 years from where we are right now with the same requirement to identify any change requests. So that's what MAD would be doing, and some of that would be in conjunction with the commission. And then on the bottom row, I envision, and this is all subject to refinement and or complete change by the commission, but I envision the commission working on doing what it can do to evaluate the guidelines. So what the MAD is doing is sort of looking out, and what the commission would be doing is more looking in, and looking at evaluating the guidelines based on really what are the criteria for that the commission has historically set out, and those criteria might be changed as a result of this comprehensive review to the extent they're not statutory. Some of these are statutory, some of these are commission's criteria in the beginning of the sentencing guidelines, but sort of boiled them down and maybe oversimplified them as public safety, uniformity, predictability, rationality, proportionality, neutrality, and capacity. And capacity there refers to resources, prison resources specifically. And not to get too far ahead of ourselves, but it's like looking at public safety would be, comparing different public safety outcomes with different interventions, probation versus prison, and how long the prison was, and what ended up happening. And following different defendants, did probationers end up recidivating more than prisoners, and were people ultimately harmed by putting somebody on probation, or was the effect the opposite of that, and that sort of thing. Uniformity, looking across the state and looking how sentencing practices and charging practices, if possible, differ across the state, and how the guidelines contribute or do not contribute to uniformity or the lack thereof. Predictability, how this really, I think, has to do with departures. How, obviously there's some predictability in terms of knowing what the presumptive sentence is, but does that predictability carry through to the actual sentence? Or is there a disconnect there due to departures, and what can we learn about departures? Rationality, are the sentences that are imposed connected with what the factors are that we want the sentences to be connected with? For example, culpability, harm, and dangerousness. Do we see that sentences have a bearing on culpability, harm, and dangerousness, or other factors that should be considered? Proportionality, similar, I would say, to rationality in terms of some of the things we'd be looking at. Neutrality would be similar to, I think, uniformity in terms of some of the things we would be looking at. Are there not only geographical bases for treating similarly situated people similarly, but are there racial differences that need to be understood? And then capacity, looking, given a finite prison capacity, are we using those resources in the most effective way. So those are some of the things that the commission would be looking at while MAD is doing their stakeholder engagement. And then the other side of that internal discussion would be a review of academic literature and looking at other states' practices, so we can compare, what has happened in other states, particularly those that have sentencing guidelines, and what have they done. We sort of got the ball rolling in 1980 with our sentencing guidelines. But there's no other state that adopted the Minnesota sentencing guidelines exactly. Everybody's tried their own different flavor of things, and some of those may have worked, and some of those may work better than Minnesota. And what lessons can we learn from that? And that would also include the recently published, what am I thinking of? The Model Penal Code for sentencing, and what can we learn from the Model Penal Code? So that, I think, would give us a pretty strong foundation in the fall of 2024 to have a sense of what phase 2 is going to look like. And phase 2 hopefully is where we'd start to identify, we might even identify some of the possible policy solutions and possible policy options in phase 1. But phase 2 is where we'd really flesh those out and begin to select those and write them up and finally come to action by the end of 2026 and present a report in January 2027. So but this doesn't really have that timeline on it. This is really a biennial change request for the next biennium, with the understanding that there would be some request in the following biennium for additional resources. As far as those resources go, and reverting back a slide, it says on this slide, cost to be determined. In our conversations with, and it was to be determined at the time, we've gotten a little more clarity from MAD. We're probably looking at one-time costs in the neighborhood of $180,000. So that would be, it's certainly a big number, but it's also compressing a lot of work into a fairly short period of time. Again, this is work that took some of these other states years to do, because they'd be concurrently contacting a number of different stakeholder groups. We're hoping that it would be well worth the cost to get all this information to the commission in an organized, an orderly way, in a fairly compressed period of time to still get us quite a bit of helpful information. The other thing to remember is all these are one-time costs. So it's not, these aren't like costs that would be growing government. They would be taking extra resources that we happen to have right now, but won't necessarily have in the future, and using them in a one-time way that will hopefully benefit the state of Minnesota for years and years to come. So that's it for the new information on number 1, the comprehensive review. On number 2, the update is that we still don't have cost estimates from Minute. So I will just say that those folks are pretty busy right now. They're pretty much any changes like this to be submitted to MMB by the 17th have to go through Minute. And Minute has to, you can't just make an IT request without having it go through Minute, basically. And so our chief information officer is not just working on our agency's request, but working on a number of agencies' requests. So I don't have a number for you on this. I appreciate the fact that these could be large numbers, and I don't know what the numbers are, but I do know that there was a bill in the legislature in the last session that would have required MSGC to basically post all our data on a searchable online platform. And that was going to be a very expensive process. It was going to be over $500,000 in one-time costs, and I think about $80,000 of ongoing annual costs after that. So I'm not suggesting that this will be that expensive. I don't know, but I hope not. But what I would propose to do, if you're okay with the concept here, which I talked about the concept last time, if you're still okay with that, I would propose to bring this back to you in November, because we will have the final numbers in November. And if you don't like it, I can ask the MMB to withdraw this. But once October 17th comes, we miss the deadline. So it really has to be on board, or it won't happen. And I think it does make sense to do MSGC integration. I think it'll help us do our data processing job and understand what sentences were, and potentially expand our research mission by doing this integration with MSGC, with the Minnesota Court of Information Systems. So I would ask for the commission's support on this. The request for the additional permanent research analyst supervisor, there's no changes here. Unless it was how I stated the salary cost, but I don't think there are any changes there. And then this remains $50,000 ongoing to basically pay our fair share of what we're getting right now for free from DOC in terms of HR and accounting services. So that concludes this presentation, Madam Chair. I know that we did have a couple of memos from Judge Larkin and from yourself on the topic, particularly of number one, the comprehensive review. But that's all I have to say on this, unless you have questions.
Any questions for Nate?
I've got some.
Commissioner Knudsen?
Nate, I assume that, I mean, the one thing's obviously missing, and it's probably not it's not an oversight, it's probably just automatic, but when you put forward your budget, you also justify and request increase in payroll and health insurance costs and other benefits, correct?
Yeah, I mean, I haven't figured that out yet, Judge Knudsen. We're kind of getting, this is the season where we've been getting other entity, like we just got our minute just gave us like within the last week their estimates for what our costs are going to be for IT services for the next biennium. A little bit before that, we got our estimate of what our rent is going to be for the next biennium. We really don't even know yet what our payroll and insurance costs are going to be. And we're not allowed to assume that there's going to be an increase in those, even though there certainly will be. So yeah, it's possible that we may need to choose just a lights on change request just to keep the boat afloat. Sorry for mixing metaphors there. But we may need to do a change request to just to continue the status quo in terms of our operations. If I wouldn't necessarily view that as being something that I'd have to present to the commission, since that's really not a change. It's just essentially responding to inflation. It's not doing anything new. It's not expanding the mission. It's not expanding the personnel base. It's just continuing what we're doing.
Right.
Commissioner Knudsen?
But I think we want to know, what we're asking for. A lot of governmental agencies are going to come in for a bit of an increase, and I think not knowing I guess the salary increase or benefit increases of the Sentencing Guidelines Commission in the past would probably do for that, just to reward staff for a job well done and just to keep pace with the market. And I think that's the board's responsibility too, just to know that. I wasn't expecting that today, but that's part of it, and I think that's something that the board should be advocating for. And so when you put all of this together, I see that we've probably got about 5 things that we would list or request in our budget to the legislature. Number one, and I think we should prioritize these. that the board should tell the legislature, these are our most important requests to advance our mission. So number one would be payroll, health insurance, benefits, take care of staff, any increases in rent and on some of the other things you were talking about. Number two, I would put as the integration with the court data. And I'm just wondering, with that, when you write that budget, you got to justify or explain what exactly and what benefit that is to the institution or to the state. I got to believe we might be able to save some staff time. We would be able to do a better job in the next thing, which is to expand the analysis of data, which I think is number three. Number four, I would argue, is to improve fiscal transparency. Although, I mean, in my mind, that's somewhat questionable since it doesn't cost us anything now. And then number five would be the comprehensive review of the guidelines. And I say that because I think it's difficult to do a comprehensive review of the guidelines, although I'm in favor of it, without the integrated court data and the additional position to expand analysis of data. So I think several of these kind of go hand in hand, and some of them have to come first before we get to the rest of the thing. But I guess my point is that I'd really like to ensure that the legislature knows what our priorities are. That's all I have.
Can I ask a point of clarification?
Commissioner Glad, yes.
I missed Commissioner Knutsen's number 3 point. What was that again?
The
1 through 5.
third priority would be to expand the analysis of data.
Okay.
That would be the additional personnel. Madam
Go
Chair,
ahead.
just one thing. So in terms of rewarding people, one of the issues that I see with our current personnel structure is we don't really have what HR people like to call a ladder. We've got 2 people in the senior position and nobody in the position below that. So that is something I'm working on internally right now and rectifying. And if we get this additional research position, we have a really nice ladder from research analyst to all the way up to senior research analysis supervisor, where at least there would be a possibility, obviously no guarantees, but at least a possibility that somebody could eventually advance up as there was attrition or retirement.
Other comments or questions?
Madam Chair, if I could.
Commissioner Schnell.
Well, I just wanted to, I appreciate it. I think one of the things that we're talking about here is I think so much of this stuff is integrated just from a state budgeting standpoint. I think to Nate's point that, operational things, base budget increases are things that is the cost of the state doing business, and, healthcare costs and those types of things will ultimately be forecasted by MMB as we go forward, and ultimately those things will get built into the increases. I would just say that, when I think about the demands we've placed on staff to look at some of these issues, to dig into the complexity of the guidelines, and I think the integration with other systems, certainly having the Guidelines Commission and the data from the courts and the intersection with a lot of the DOC work that gets done would be just so immensely helpful, and I think critical to the efficiency of government operations. And so I would hope that that we would be able to support this request. And I would just say it's not lost on me that ultimately, I think much of what is being proposed, I think certainly falls within within the kind of the authority, it seems, of the executive director. And, you know, we're asking for an additional position. I think that is certainly something that we look at, but I think a lot of this does seem, at least operationally, as falling within the governance authority or the responsibility of the executive, and certainly with the input and advice of the commissioners. So, but I certainly am supportive of the request that's being made.
Commissioner Estrada?
Excuse my throat here. I piggyback off of what Commissioner Schnell talked about and Commissioner Knudsen. I also want to say that I really appreciate staff for really putting this timeline together. This is very much a proactive approach versus being reactive. So often our commission comes together because legislation has ordered us to do a comprehensive review of this section of the guidelines or that section of the guidelines, or we hear from people who come and testify and say, we want this. And this is really a proactive review, which is really what this body is there for, to consistently look at our practices, our sentencing practices and patterns, and the simplicity as well. So I would support this for, you know, the integration of the data system and having the resources that we are needed. I also think about some of the conversations that we've had in terms of when we are doing comprehensive reviews and how staff are really, you know, lacking resources and being able to gather the data. Oftentimes we hear we don't have access to this data, where it's going to take, you know, staff manually to have to go through every case, and we just don't have the resources for that. And then we're put in a situation where it's like, well, do we do the demographic impact statements or do we do this? And this is an opportunity to provide those resources so that we can effectively do the work that we're designed to do. So thank you to staff. Thank you, Nate, for putting this together, as well as the timeline. And again, taking that proactive response versus waiting for something to happen and being asked to look at certain sections.
I also want to thank Nate for the work that he's done to put this together. I only knew about the MAD thing about 2 days before you all did, when he told me the work he'd done in the background to figure out alternatives. And I love that. Like the price tag scares me a little bit, but I think that the amount of information that we can gain from talking to all the relevant stakeholders of the guidelines, I think is just going to be invaluable to the work of the commission. So I think that is a really creative way to make sure that we get good, solid input as to what the field, what the community, what practitioners, what victims, what people who've been through our system are looking for in the guidelines. I think that's going to be really great. So I'm excited about that piece. So I really appreciate you tracking that down and also taking the time that you did to talk with folks from Pennsylvania and Washington to get us more detail on how they went about it. You put together a difficult proposal in a short amount of time, and I think you've done a great job here. I personally support all of the components of the budget request. I'm intrigued by Commissioner Knudsen's discussion about prioritization. I think at some point Nate will pin us down on that because he will have to say something to the legislature. So that's something that we can think more about as we go. But what Commissioner Knudsen said is all of these pieces are interrelated, and that's absolutely true. So that's why I'm having a hard time figuring out priority if we have to make the call. But anyway, I just that's about all I have to say. Any other comments or questions or anyone? Commissioner Moore.
Thank you, Madam Chair. I would also join in the, I guess, compliments for staff and putting this together. I also agree with the comments that Commissioner Knudsen made about prioritization. Some of this seems to have a real, we need to get this done like soon, if not already, have it done. And the comprehensive review seems, something that is aspirationally desirable, but I just personally worry just a little bit about the time frame here. I mean, maybe you're being realistic, Nate, on that, talking about 4 years. That may well, for a comprehensive review, that might be it. I just wonder if there's a way, and maybe we can't break this up into component parts. Maybe it has to be looked at all at once. But is there any way that the review could be focused a little bit more on a particular area of the guidelines where we could get started? I just wonder about 4 years, the window of that just seems like a really long time. And that's a, I think as Commissioner Larkin points out in her memo, the realistic plan here, I mean, we heard from Washington, in Pennsylvania about what happens during this process. And, what we've heard through our stakeholders is some focus on some particular issues of immediate concern. And I just wonder if our limited budgeted resources might be better put to breaking this into parts where we could really dial in on one issue. Now, I realize that it's hard to look at one thing without maybe considering the impacts on other issues of the justice system. That's hard. For instance, to say we want to just focus on recidivism, repeat criminals. What are the factors that go into that? And that's a complex question. But that's the sort of thing that we heard through the input, I think, from our stakeholders. That's a key priority right now, is looking at what are the guidelines doing to address public safety in the areas. And you have the thought balloons here. I thought were kind of helpful to remind us about what the questions are the comprehensive review might answers. And one of them, are the right tools available to address serious and violent crime? That's clearly a key question right now that's being asked. And, that's not just a guidelines commission question, that's a big question. But I wonder how, if there's any way that this timeline might be able to be more condensed. Maybe it's not realistic to expect that, but going to the legislature and saying we want money for a 4-year study right now, maybe Commissioner Knudsen has a better sense of how that would be responded to. But I think there's a little sense of urgency right now on some of these issues, and I wonder if this is being responsive to that. Aspirationally, I do not oppose the concept. I mean, the concept has merit, it's worthy. There are a lot of good things that are part of that discussion, but it's got a tinge of academic to it at a time when I think what we're hearing is a desire for action, a desire for, responsiveness. And so I'm just a little concerned about how that might be perceived at the legislature. But I don't want to get in the way of simplifying the guidelines, streamlining it, making it more effective, more useful for stakeholders. Those are all desirable goals. And I think the questions that Nate's asking are good ones. I would just like to think that maybe we could move a little faster than 4 years. That's my concern.
So, in the 8 years I've been here, I know that Chair's predecessor, Chair Dietzen, did a review or led the commission through a review of the criminal history score. So that's, I think, more within the scope of what you're talking about, like looking at a particular thing. And criminal history score is pretty big, and it did take a few years just to get through that element of it. But we didn't have additional resources for that. That was an internal thing. So we didn't have the resources to do, the surveys and all that sort of thing. So we could do something like that. It wouldn't be. I sincerely doubt that we could do a comprehensive review of the, taking the guidelines down to the studs, basically, figuring out, sort of a remodel project, as opposed to a redecorating project is kind of how I think of it, right? We could do something with a shorter time frame and fewer resources if it had a narrower scope. And that would be kind of more conventional in terms of what the commission has done in the past. This would be new.
Commissioner Lett?
Thank you, Madam Chair. I don't want to repeat what everybody else has already said, but I do think that a comprehensive review in my mind is sort of the end result of some other things that have to happen first. And I think it's really data driven. And as I've heard other proposals that have come through on different things and we've asked questions, it's all about data and the personnel that can analyze the data. And I think that if we have those things in place or in our toolbox, I think a comprehensive review is likely more effective if we have that information. Some things that I think about are, and I listened to the one of the hearings where we were talking about this data issue. I think Director Wrights was there, and I think there was a representative from the County Attorneys Association that talked about that. And I heard one of the representatives indicate that, well, everybody has access to MNCIS. Everybody doesn't have access to MNCIS, so it's already public. It isn't public. And so the idea that that information is out there, but we don't have a way to get it and then somehow look at it is really, to me, a frustrating thing. But I think it's important because when we look at what's happening with our data that we currently have, we have convictions and we have the severity of the conviction and we have the end result of the sentences. There's a lot of stuff that happens between those 2 points on any one offender. I mean, people get stays of adjudications, they get departures, we have specialty treatment courts. We have lots of things that happen before anybody ever gets to that end sentence where they're sent to the Department of Corrections to have a sentence. And so understanding that I think is important because we've seen some graphs and people said, hey, why is that trend happening? And people are like, we don't know. Well, we don't know because we don't have the data. And so I do think that if we're going to be successful in doing a comprehensive review of the guidelines, I think we have to have the data first. And it sounds like that's a resource-driven issue by getting the technology and also getting the people who can give us that information in some sort of usable way. And so I really would support us trying to get those necessary resources to get access to that data so that we can really look at it and get weedy about sort of what's happening, because I don't want to be responsive to the things that are happening in the current moment and not really understanding sort of why that's happening or if our response is appropriate. And I sort of feel like right now it's very topical. And in order for us to know better and do better, I think we have to have that data. And so in my mind, I think the data has to come before we can do this overall review of things. And so I would really support anything that we could do to get that to sort of be the precursor to moving on to a larger review of what's happening with our entire guidelines.
Director Wrights.
Thank you for those comments. And I will say some of it isn't that we don't have the data, it's that we don't have the research resources to tap the data and get into it. Which, you know, as Commissioner Knudsen said, some of these are interrelated, and I think having the senior research analysis specialist supervisor would help here. One thing that I skipped over when I was presenting this a few minutes ago, so I brought the slide back up, is this lower right corner on slide 10 here, which the vision, this is a change from last month that I should have pointed out. Because MAD is doing the stakeholder engagement, I think we can focus, we don't have to do that, which I think is really helpful because it's really not our area of expertise, but we can hire a temporary research analyst during this, at least first biennium, to drill into the data. And the idea is that person's only job would be to work on the data for the comprehensive review, in addition to having academic consulting services. And the idea there would be access to sort of higher level research capabilities if we needed to, you know, maybe run more complex regression analyses and that sort of thing on some of this data. And also it would be helpful for doing some of the literature reviews that we were talking about later on in the first phase with those academic consulting services. So that is the idea here, is that this research analysis specialist would answer the mail there. And I'm thinking of having that be an existing person. So this temporary position would essentially backfill the regular staff work, and then we'd have somebody who already knows the sentencing guidelines to step away from her usual duties and work on the comprehensive review. that's the direction the commission chooses to go.
I would say too, if you wouldn't mind putting the timeline back up. You and I, because I had the same question, but the project planning piece of it there, we're at the front where we're trying to figure out what this is. I mean, part of it is we're working with MAD to give them what they need to do their piece of the work. But that would also be the commission's opportunity to develop the research questions that we want the staff to analyze and to prioritize those research questions. So I think Commissioner Moore, that's where we sort of get to making sure that we are doing the research that needs to be done. You know, there's a lot of questions here, a lot of potential questions that we could answer, and it's probably more than we could do, you know, through the whole life of the project. So I do think the commission has a role there to try to hone in and sort of settle on the scope of what the data analysis is going to be, barring, you know, the staff coming back to us and telling us we did this and now we're going to have to look here because it, you know, raised these other questions. But I just want to say that there is an opportunity there to prioritize, you know, how the comprehensive review, how the data side of it would go as well. Questions or comments? Oh, I'm sorry. Thank you, Commissioner Middlebrook.
Thank you, Madam Chair. I just wanted to also say thanks to the staff and to Nate particularly. I really appreciate this timeline. And I see everything as being really integrated, that they kind of all overlap as well. I think the other thing that I just would add on to what the chair just said is between the time, like right now we need to make the request for the funding. And that's kind of what's driving everything right now, because that request has to go in. If we don't put the request in for this next biennium for all this, we've got to wait 2 more years. And if we're talking about trying to even do parts of a comprehensive review, I think that we need to ask for the money now. We also have time between putting that request in until we see what happens to kind of hone in on what our priorities, you know, may be on certain areas. I mean, I don't see the comprehensive review precluding us from doing other things that we feel need to be done more urgently. I guess that I don't see that as the only thing that we'll be doing over this time period. So I guess in that sense, I really like this timeline. I think that working with Matt is a great idea, because that will help us out with like the other 2 states that we heard from. It seemed like a lot of their time got extended because they were just doing things consecutively instead of trying to do it at the same time. So I just wanted to add that in and say that I do support the request as Nate's written it up here.
All right, Commissioner Larkin.
Just some questions.
Sure.
Because I heard Executive Director Nate say this is sort of like taking it down to the stud. So is what we're talking about, we're gonna rewrite the guidelines? Is that what's a potential result here? And if so, then who's going to draft all the proposals? I'm just trying to understand how this will work. I mean, at some point, does staff come to us or this outside research person and say, we've studied all this, now here's what your new guidelines should look like, and give us something to vote on? I just really want to understand how it will work, because, you know, when I've been involved or know of situations where there have been comprehensive reviews of existing rules or creation of rules whole cloth, sort of like the group debates each, should we make a change here? Yes, no, why? Kind of go through. Is that what we're going to do? Or are we going to farm this out and someone's going to come back to us and say, based on the data, here's what your guidelines should say? What do we envision happening in terms of how we actually end up with new proposals for the commission to vote on?
Exactly right.
So Pennsylvania and Washington did more of a farming out process where they had these groups sort of look at the guidelines from the outside. It's not how I'm envisioning this. Based on the commission's statutory role, I assume that the commission will be making these decisions about amending and promulgating the guidelines, because that's your job according to the statute. So I would say, one, I would view those as phase 2 issues. So those would be things that I think 2 years from now, the commission would be sitting around saying, okay, we've learned a lot of information. What fundamental direction do we think we're going? Are we going to do like incremental change, keep the guidelines existing structure, but do incremental changes? Or are we going to do a rewrite? If we're going to do a rewrite, then one of the things that needs to be in that change request in 2 years is probably some kind of a staff attorney or draftsman or somebody who's able to write up those guidelines for the commission. I mean, so we'll need those kind of resources. So the resources that we'll be requesting in 2 years will depend on the direction that at least how I view it, Madam Chair. It's obviously the commission's vision and the chair's vision, but I would view that being sort of a decision point that the commission will be looking at in 2 years and saying, what should phase 2 look like? Are we happy with the overall structure and we just want to make section by section changes, or do we want to, based on all this information that we've gained in phase 1, want to really take it down to the studs? But I think everything should be on the table for it to be a comprehensive review, within the framework of the charter statute.
Commissioner Larkin?
If this goes forward, is there any chance we're going to hear as to any interim proposals addressing a particular part or issue under the guidelines that, well, we shouldn't make that change because we're in the process of doing a comprehensive review and we don't know how this will fit within the comprehensive review?
That's up to the will of the commission. I mean, it could be that you find, an open wound that needs to be, given first aid in the course of the comprehensive review, that you make an immediate change to the guidelines as they currently are. I don't think there's anything about the nature of the comprehensive review that would prohibit the sort of normal amendments that the commission does all the time.
Commissioner Larkin?
I'm just concerned that it seems to me if you're doing a comprehensive review, it's with the notion that we haven't looked at these, we're not sure that this is how we should be doing it, so we probably wouldn't make any changes in the meantime. We would wait till the end of the comprehensive review. Because otherwise, people might just say, well, why don't you just piecemeal? If you think there's a problem here, fix it. They all relate, absolutely. So that's my concern, that we go off on the path of a comprehensive review, and in the meantime, people from all walks of public life saying, what's going on with sentencing? Why aren't we doing something different with sentencing? And then our response is, well, we're in the process of a 4-year comprehensive review, so we're not going to deal with those issues right now. That's my concern. Certainly people, from the governor, AG, to U.S. attorney, editorial boards, everyone is saying, what's going on with violent crime? Why are repeat violent offenders constantly showing up on the street and reoffending? What can be done about it? And it seems like, as the Sentencing Guidelines Commission, we should be front and center in answering that question. And I'm just concerned that might not look good if we're not going to do anything to answer those immediate concerns because we're doing a 4-year review. That's my concern.
So for instance, I hear the same concerns that you do, and I'll be honest that when I think that should be one of the top priorities, right? Like we should start looking at how the guidelines address repeat violent offending. But it's also so I would see that being part of the review as well, that we would look at that specific question. And it's one of those things that it's complex, because when you think about repeat violent offending, that's built into our criminal history score. It's built into the rankings that we have on the grids. It's built into additional modifier provisions that exist throughout the guidelines. It's also built into additional statutes that interplay with the guidelines. So we'd really have to get a sense of like, what types of crimes are people concerned about? What issues are stakeholders seeing that they feel are not currently being addressed by the guidelines? And then what are the existing mechanisms to address them, and what's sort of happening in the gap there? So I would actually see that as part of the review. But that doesn't mean that we couldn't do something in the meantime if we found something really serious that needed to be addressed. But I do think that it's an important part of the review. If we did find, for instance, that we needed to make a change that would actually result in more people being sent to prison, one of our constraints is capacity, right? So then we'd have to figure out what's the counterbalance? Is there a counterbalance needed to allow for that, to take up that capacity? So we might have to think about, holistically, we might have to think about, do we have to make changes on the bottom end as well so that we can make sure that we're putting those sentences in place on the top end? So those, I do see that as part of the comprehensive review. And I also see that as part of, some of the prioritization that we could be doing to sort of figure out what do we look at first. And there's nothing that says staff can't be bringing us data, along the way that we can be looking at so that we're starting to see the whole picture.
I agree with everything you said. And I think it's difficult because yes, that's part of the comprehensive review, but I think most people would be asking, why don't you just deal with that part now and not make it part of something that's going to take 4 years? And I agree, it all relates, but I think I'm concerned there will be a perception that we're not taking steps that maybe we could take to address that component of the comprehensive review now, because I think we know, okay, carjackings, gun offenses, I think we know what the concerns are, and it seems we could maybe spend the next year addressing that component. I just hate to see things get delayed because they're made part of the comprehensive review. But I do agree with your assessment. Could I have one more question?
Commissioner Lecken?
I know at one point there was a proposal that we would buy out the contract of someone in academics who could do the research. Is that still the plan? I don't know if that was our plan or if that was just something that could be done that somebody else had done.
Madam Chair, I toned that down after talking with Pennsylvania and Washington and MAD. I think, so basically, that converted into just the consulting fees. So we just have one research staff working full-time who would know what they're doing, and then augmented by the academic consulting fees, but it wouldn't be the quarter-time buyout anymore. So I'm kind of dropping that down based on my conversations primarily with Washington and Pennsylvania.
So we would outsource those research calculations. I'm not a researcher, so I apologize, I'm using the wrong terms. That can't be done by someone we put in that position just because it's beyond their capacity in terms of the task at hand.
Yes, although it's hoped that that new person, again, with the other request that for the research analyst supervisor senior might be able to bring some of that in-house to us, but at least in the long term, but for the academic review or for the comprehensive review, that's the hope is that person would be able to both do a lit review of the academic literature concerning sentencing and sentencing guidelines, which there's a ton of, and also do some of the higher level quantitative work.
Commissioner Larkin?
Do we know, are there other areas of government where they do this, where they kind of outsource that sort of research function as opposed to having people on staff do it? And are there any concerns about conflicts of interest when doing that? I mean, I'll just be honest, it's like there were calls for bills that all of us would have to face confirmation hearings. But how will it be received if we say we're going to outsource some work? Are there going to be questions about that person's competencies, biases, other things? Could that be a problem for us?
Okay, well, my naive answer, maybe it's naive to say this, I would say I don't think so, just because to answer your original question, do other agencies outsource this kind of work? Yeah, all the time.
Okay.
So for instance, the Department of Corrections is lucky that they have Grant Dewey. They actually have 3 PhD level scholars that lead their research department. They're amazing. Most departments of correction don't have that level of staff, and they don't have that in staff capacity. I actually, in my day job at the Robina Institute, we work with probation departments across the country and parole boards across the country who don't have that level of staffing, and we do that kind of analysis for them, and we help them answer questions that they need that type of work done for. And often we're brought in to do that work to be the independent assessment of something they've done. Like for instance, we I won't name the state, but we analyzed the parole guidelines that were developed in a particular state to help them understand if they were working the way they were intended to work. And they needed an outside independent assessment for that so that there wouldn't be any perception of bias from their own parole board in saying that they work or don't work. So yeah, it's sort of done in that way all the time.
Would we look at using the Robina Institute?
No, because I believe there is a conflict of interest.
I think so too. That was my next question.
Yeah. No.
And I should say, and not to be a downer here, but that's assuming that the chair remains the chair. So that's the chairmanship and the membership of 8 of you is all up for grabs next year. So we can't assume that this is the commission that will be doing the comprehensive review.
It's true.
And then,
Commissioner Larkin?
in terms of a comprehensive review, I would just like our request to commit that ultimately our primary concern will be public safety, as it must be, driving all the decisions and all the components of the review.
Yep, absolutely. You got any argument there? All right, any other discussion? I want to make sure we have enough time for all the rest of the items on the agenda. So Nate, what do you need from us?
Well, I guess the final question is, does the commission endorse these change items? So I think I'd be looking for a resolution to endorse the change items.
Or a motion?
Madam Chair,
Yes, Commissioner Schnell.
I would move that we support the staff recommendation to advance the budget request through so that they can present that by October 17th to MMB.
All right, so we have a motion to move this budget request forward. Do we have a second? Commissioner Estrada seconds. Any further discussion on the motion? Hearing none, if you could take the roll, please.
To the Schnell motion to direct staff to advance the budget change items to MMB by October 17th. Estrada?
Yes.
Estrada, yes. Hansi? Hansi absent. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
All right, with that, the motion is approved unanimously. Thank you, everyone. All right, so when you are ready, Nate, we'll move on to the next item, which is the sex trafficking.
Yes, sex trafficking and prostitution.
Sex trafficking and prostitution. Okay.
All right.
There's my agenda.
Madam Chair,
Commissioner Schnell?
just want to let the members know I'm getting into an area where I'm going to lose cell count. I will try
You
to
already
get back
breaking up?
when I get back into it. Okay, sorry. I'll try and reconnect.
All right, thank you.
All right, so this, so we're moving on to the comprehensive review of sex trafficking, which the commission has expanded to include prostitution offenses. And this is the October discussion. So what has to happen at this meeting? Discussion. Nothing really has to happen. There's no legal deadline for completing the comprehensive review of how the sentencing guidelines address sex trafficking and prostitution crimes. But the commission has said in the past that it would like to wrap this up and submit its report by the next legislative session. So if the commission still wants to do that, and if the commission, as part of the report, wants to make changes to the sentencing guidelines effective in 2023, it has to advance a proposal at the November meeting, as I've already discussed. To do that, it must have discussed the proposal or a prior or similar version of it at today's meeting. So today's goal is to discuss all November decision points. If you have a decision point that you want to bring up in November, please discuss it at today's meeting. So this slide is just to sort of a table of contents of all the stuff that we gave you. I apologize for that. There's a lot here. I will remind you it's a comprehensive review, and this is kind of the culmination of that comprehensive review. So it's to be expected that there would be a lot of information. So we have a number of staff issue papers. 4A1 was the background of the review mandate. A lot of discussion about what the Central Minnesota Human Trafficking Task Force recommends. That's because they were the proponents of the bill that ultimately resulted in the review mandate, and they had a lot of helpful information for us. We also had has the sex trafficking and prostitution crimes and the history of the sex offender grid, because a lot of these had to do with moving offenses to the sex offender grid. So that was 4A1. 4A2 was comparing different options for ranking aggravated sex trafficking, which was the primary recommendation from CMHTTF. 4A3 was should prostitution crimes move from the sex offender grid. So this dealt both with child prostitution crimes, which upon further reflection, I'm suggesting we call something else. And it's not called child prostitution in the sentencing guidelines, but I'm suggesting that we call it using a minor for prostitution, because child prostitution makes it sound like the child is the defendant. And then 4A4, so 4A4 is new, is sex trafficking and severe violent offense. So I spilled a lot of ink in there, sort of going over the history of the severe violent offense modifier, which the commission established effective in 2019, and gave you some history on that. And honestly, that's relevant, I think, to some of the discussion we just had about how the sentencing guidelines treat severe violent offenses. So kind of a timely topic there. At 4A5, also new, much shorter, should permissive consecutive sentencing apply to prostitution. And then, so those are all the 4A staff issue papers. And 4B is sentencing practices data for sex trafficking and prostitution. 4C is the estimated impact of various sex trafficking and prostitution proposals. And these are all documents you've seen before. And then you've also seen the sample draft language to implement these proposals. Ranking aggravated sex trafficking and moving prostitution offenses to the sex offender grid. So what are the main sex trafficking decision points that we should discuss today? One, aggravated sex trafficking currently is treated as a modifier. So the aggravated part of sex trafficking is a modifier for sex trafficking. So it adds 48 months to the presumptive sentence. Should it be a ranked offense instead? That's what the CMHTTF is recommending. Staff also agrees that makes sense because it allows for broader sentencing ranges. It repeals this odd single offense modifier. Normally modifiers modify like a class of offenses, like attempted offenses and so forth. But this is basically a modifier that only applies to aggravated sex trafficking. Not entirely unprecedented in the guidelines. There's another one that has to do with criminal vehicular homicide that follows a conviction for a DWI. But it's pretty unusual to have a modifier that only applies to one offense. On the other hand, so the flip side to this is that some criminal histories durations actually go down. And also this requires more prison beds. So that's an expense to the taxpayer. And we don't have the ability to tax the taxpayer. So it's that's a consideration. Second main decision point, if aggravated sex trafficking first degree involving minor victims is ranked at severity level A, which is the staff and CMH TTF recommendation from number 1, should aggravated sex trafficking with adult victims be ranked below that at severity level B? So right now, those offenses are ranked at B and C if they're not aggravated, right? But the idea is we'd be ranking them. So naturally, you'd rank first degree at A, or else you'd have to come up with a new severity level. Should you rank second degree at A, which is what the CMH TTF recommends, or should you rank it at B, which is what staff recommends? So staff's recommendation is to rank it at B because that would retain this rational severity increase when there's this, when the offense is more severe, when the sex trafficking victim is a minor. So it would retain a distinction between aggravated offenses involving a minor and aggravated offenses involving an adult. Whereas the CMH TTF points out that the stat max for both offenses is the same. In fact, they're not necessarily even distinguished in the statute. So CMH TTF thinks it makes sense just to rank them both the same at severity level A.
So let's go ahead and stop on this slide and just have a little discussion. Commissioner Larkin, it sounds like you have a question.
A question for the discussion.
Yeah.
First degree crim sex. Do we distinguish the ranking based on whether the victim was an adult or a juvenile or minor?
Not for first degree, because all first degrees apply to, they all have the 144-month mandatory minimum.
So this is similar in that they both have the same statutory max, and the statute doesn't distinguish between adult victim, minor victim.
Well, I
It
guess
does for the underlying offense, but
yeah,
not the stat max for the aggravated version of it.
there are a lot of distinctions in the crim sex statutes overall that have to do with age, and age is one of the things that gets you to first degree. So like if you had the same offense against a 14-year-old versus a 12-year-old, you wouldn't be in first degree land if it were a 14-year-old, where you would be if it were a 12-year-old. Does that make sense? So there's already some age differences that would be baked in to the fact that it's a first degree. And that doesn't apply to sex trafficking, because sex trafficking, the distinction that gets you to the degree itself is whether.
Which is,
Yeah, so.
generally speaking, on the guidelines grid, is the presumptive sentence higher if the victim's a child for a given offense, other than where the age of the victim doesn't matter? Because I mean, I see what you're saying. Well, rationally, it seems worse if it's a child. I agree, but if the statute doesn't make that distinction, why attempt to maintain or create the distinction in the guidelines? Why not just rank them both at SLA, I guess?
Yeah.
And then perhaps you could have upward departure grounds based on particular vulnerability of the victim is very young age.
I mean, it's a really interesting question, because the statute does make the distinction for the non-aggravated offense, right? But it doesn't make a distinction for the aggravated offense. So it depends on how you think of the aggravated offense. If you think of the aggravating factors as aggravating first and second degree, which is how the guidelines think of it now, right? The way the guidelines are written right now, you take the first or second degree and then you pile on 48 months on top of that if it's aggravated.
And what are the aggravating factors?
Yeah, can we maybe just pull up, is it possible for you to pull up the statute? It's in 4A4, if you want to.
Yeah, let's see if I don't have that. Sure, let me.
While he's doing that,
Yes.
can I make a comment? I'm just gonna be honest with you. And you've given us all the information. This is so dense and so complicated. That's why I didn't put forth any proposals. I'm in no position to put forward a proposal or to vote on anything. I'm just gonna be honest with you. And it's not because people aren't trying, it's just because there's so much here.
All right, so this is 4A4 and it does happen to have the aggravating factors highlighted.
Prior.
Yeah, so there, and these are discussed more in 4A4, but, so,
What I would say, let's like look at the whole statute. So scroll up.
yeah,
So subdivision 1A is sex trafficking of a person who's under 18 years of age. All of that is a person under 18. And right now we have that ranked higher, higher. Now scroll down to subdivision 1A.
can I just make a technical point here? So this is all under subdivision 1, and subdivision 1 is called solicitation, inducement, and promotion of prostitution, sex trafficking in the first degree.
Right.
From that, CMHTTF makes the argument, Ole Sweden made the argument that this is, so A is first degree and B is also first degree. Like he views them all as being first degree. He doesn't view this as being a second degree, but this applies to paragraph A, which is first degree, or 1A, which is second degree. So here's 1A. And 1A is the same as 1 parens A. Sorry about that. But it doesn't have the element that the victim be a child.
The sex trafficking is defined the same except for age is in the subdivision 1A, 1 parens A. So up here, the stat max is 25 years. When age is not part of it, the stat max is 20 years.
Okay.
If you have an aggravated form of either of those, then that's this paragraph B. And that's where the stat max of 30 years is.
So on that one, they don't care if the victim is adult or child.
It applies to both paragraph 1 parens A, first degree, and 1A, second degree.
Which is over 18, under 18.
Right.
Well, hasn't the legislature then told us that they don't want us to distinguish between adult and child when it comes to aggravated offenses? And if so, I don't think we should. It should just be the same ranking.
That's CMHTTF's argument, yes.
So that's definitely one interpretation that you could have.
And I'm not suggesting that's irrational.
Yeah.
I just think consistent with what the guidelines do now, and consistent with the fact that it is a statutory distinction that makes sense to make a distinction, because it's, it seems like a worse offense if the victim's a child. Then, that's staff's recommendation is to keep it going, but I'm not disagreeing that Ole makes a good point too, so.
And Commissioner Ladd had a.
Thank you. I just wanted to clarify something, and perhaps I misheard something that the director said. So when we were talking about the crim sex offenses related to victims under a certain age and then over the age of like a 12-year-old victim versus a 14-year-old victim, actually first degree offenses can happen with a 16-year-old victim, depending on other factors.
They can.
And so it isn't just an age thing that triggers that first degree mandatory minimum of 144 months for the first degree designation. It's not a second degree just based on an age thing. There are some other things about, there's force, coercion, position of authority, significant relationship, all of those sorts of extra things. Age is a piece of it, but it isn't just a hard cutoff for a certain age. And I just wanted to clarify that because I know you had asked the question, do we make that distinction with the crim sex offenses for first degree? And so we have, victims under age of 18 and a bunch of things that can be first degrees, and those ages can fluctuate all the way up to 16 while they're still under the age of 18. So I just wanted to clarify that. And so I would tend to agree with Judge Larkin in that it seems to me that the legislature has put that language in there. And so I'm not sure what we're tinkering around with. And so I get a little worried about that because we haven't been asked to do something about that. The legislature said, this is what we think this means and this is what this is. So why we're trying to parse it out, I guess I don't know why we're doing that.
Yeah, if I may, Madam Chair, and I'm not trying to debate, I mean, the commission has done that with crim sex offenses in the sense that there are crim sex offenses with the same statutory maximum, like criminal sexual conduct in the third degree has one statutory maximum penalty, but the commission has ranked that offense at, I think, 3 different severity levels, depending on what the commission views as the severity of the offense. So the statutory maximum has not historically been the end of the, it's certainly a very important part of the conversation, but it's not been historically the end of the conversation.
Commissioner Larkin?
I just,
Oh, and then Commissioner Middlebrook.
I'm sorry, just my training and the way we think about things when we're looking at statutes is this is all in one statute. The legislature very could have easily said, if you violate paragraph A within this time, it's this. If you violate sub A, it's this, but they put it all together after saying, okay, paragraph A, it's 25 years. 1A is 20 years, if I'm remembering correctly, but enhancement of either one is 30 years. It just seems the plain language to indicate that the legislature thinks the repeat offense or the aggravated circumstances take you to the same place. So I guess that's where I would stand on that.
Commissioner Middlebrook.
Thank you, Madam Chair. I guess I'm looking at it from the standpoint of we're looking at whether or not we're going to keep the modifier, which right now modifies first degree and second degree, and that's how the guidelines are right now. And I guess it's just trying to whether we're going to be consistent in treating those differently by moving them to the ranking on the grid versus the modifier. I guess that's how I was looking at it. And so right now, if it's a child involved, it's first degree sex trafficking. If it's an adult, it's second degree. And right now, the guidelines add a 48-month modifier on to each of those, depending on which one. So they're basically ranked differently for the aggravated offense, and it's whether we're going to stay consistent with that and rank one at A and one at B to keep that consistency. That's how I was looking at it.
That's how I was looking at it as well. Even though the legislature, whenever the legislature defines crimes, the maximum sentence is, the maximum penalty is our signal about the seriousness of that offense and also the seriousness of that offense in relation to other offenses. So, it definitely is more serious than either first or second degree. The question is, then our job is to break that down and turn that into sentences for each case. And to me, if we move it to a ranking, I think sort of maintaining that A-B structure makes the most sense to me.
Madam Chair, we have drafted both of them up. So when you look at the draft language, I think we highlighted the language that would apply if it were I don't recall right off the top of my head, but one of them is highlighted. So if you pick if you put the staff recommendation, you'd go without the highlighting, and if you pick the CMHTTF option, you'd go with the highlighting, or vice versa. So it's all in there. I'm sorry, you want me to pull it up, man?
I think it would help me to see it, because I
Okay.
think that's where you had the nice kind of ranges.
No, that's the impact, that was, I'm talking now about 4D1, and I think you're talking about
I'm talking about
4A2.
this.
Yeah. So that's this, I'm talking about the sample draft language. So it's, okay, so where the language is different, the staff is yellow highlighting and CMHTTF is blue highlighting is how that works. So depending on which direction you go in November, you'd either go with the yellow highlighting or the blue highlighting, or if there's no highlighting, it's common to both. And a lot of these changes are common to both. So just wanted to point that out, that both of these are on the table and both of them are fair game for votes in November.
Commissioner Larkin?
Just trying to figure out what chart to look at to see this. Sorry.
Sure, so
Where is my note?
you're on 4A2. And you're looking at the figures at the end. So for this one,
Okay, I think it's the last page, what we want, this. Because this would show aggravated
Yes,
at B and A.
yes, right.
Okay, that's
exactly.
the one to look at.
So, right, because there's no difference with respect to first degree aggravated, staff and CMHTTF are both the same. So the only other option would be the status quo, as far as what's been discussed.
So on this page 5 of
Yes.
ranked aggravated sex trafficking, this is what we do now.
And
And
by,
then if we split them, this would be adult, this would be juvenile victim.
correct.
Okay,
So by this, you're referring to the dark blue is it's labeled aggravated current guidelines plus 48 months. That's what we do now.
okay, and those ranges show the 48 months added in already.
They,
Okay,
yes, right. And then the green is if it were ranked at severity level B, which is a staff recommendation. And A is if it were ranked at severity level A, which is the CMHTTF recommendation. So again, this is an adult victim aggravated circumstances.
okay, but staff recommendation would also be adult and juvenile. The aggravated ranking for adults would be different than juveniles.
So that would be figure 1. So figure 1 is for first degree sex trafficking, and there's no difference there. So that just shows current guidelines and if ranked it. Yeah, so figure 2 just applies to second degree. That's the only difference between the staff and CMHTTF is its second
Well
degree.
then, for first degree, figure 1, why don't we have another column? I mean, I'd like to be able to look at it and go, okay, here's what we do now. And then for aggravated, if we were to do adults at one level, kids at another, here's how it would look. But this doesn't tell us this because this first one is not aggravated.
Look at page 5.
Well, I was told that we can't look at because that's second degree.
Yeah, so
Well, this is kids then, right?
yeah, page
It's
3
first
is
degree.
kids, first degree.
This is kids.
So it's showing you, well, the purple one is non-aggravated, just for reference, but that's what we add the 48 months to. But so blue is
Oh, I see. So first degree is only juvenile victims.
only juvenile victims,
Okay.
right?
And second degree is adult victims.
Adult victims.
That's correct.
Right.
But the aggravating statute doesn't distinguish between adult and juvenile,
It applies to both,
applies to both.
or doesn't distinguish, it depends on how you look at it, yep.
Okay, so this last column where it says on page 5, aggravated is if ranked at SLA,
Yes.
that's what the sentences would look like for second degree, which applies to adults, but it doesn't show us what it would look like for first degree ranked at 1A for juveniles aggravated.
Right.
The last
Figure 2 does not show first degree, just second degree.
Because
It would be
that's
the
what I'm
same.
looking.
It'd be the same as that last
Yeah,
column.
It's that last
because
column.
The proposal is move them both to severity level A,
Okay.
or move first degree to severity level A and move second degree to severity level B.
Okay, so page 5 then does show me what I'm looking for.
It
even though
does,
it's-
yeah.
Okay, thank you very much.
Yeah.
That's what I want to see. How would it look?
Yeah.
Adults compared to kids if we treated them differently. And
Yeah.
that's shown on this.
That's
Okay.
true, I
It
didn't
wasn't the
understand that.
intent, but
didn't
it
understand.
does
Wasn't
show
the
it.
intent, but that's what it shows.
Right.
Thank you. That's what I was like, all right. So let me just look at that for a second. So, and I'm sorry to do this, it just helps me to think through it.
I think it's very important.
That's what today is all about.
All right, so what I can see from this is, if we were to say, get rid of the 48-month enhancement and rank juvenile offenses at A, nothing would go down. All of the resulting sentences would be higher. But if we said get rid of the 48 months. And for adults, we rank it at B. There would be one potential for a lower sentence. However, that's only a potential because this is a range and it's probably not much of a difference. So it goes down a little bit for the adults if we get rid of the 48.
Yeah.
However, a judge in a particular case, you still have a range. You could go up to the top, so you wouldn't have to go down. It's
Yeah, they
just
actually have a wider range.
a wider range.
Right.
In criminal history 4, the top of the range is actually higher under the status quo than 4.
So criminal history 4.
But
okay.
that's the only one where I don't see that the
Sure.
top of the range is constrained.
Which one?
Criminal history is 4, so it's, yeah, so it's the 5th one in because there's a criminal that starts at 0.
Oh, I see what you mean.
So-
Okay. But the middle is the same, but the top is,
Now the middle's down too. Criminal history 4 is, the presumptive, it looks like 150 months at severity level B, and it's something higher than that. I would have to get out the original document to tell you what those numbers are.
so I'm comparing SLB with the plus 48 month column.
Correct.
And to me, it looks like for,
So
it
it's,
looks like the center is higher
so,
for SLB than it is for the 48 months.
oh my gosh, I'm sorry. I was confused. You're right.
Yeah.
You're right. I was mixed up.
It
I
looks
was
to
comparing
me,
3 to 4.
yeah, the only place it matters is at criminal history score 0. The middle of the range is lower than if we're doing a 48 month. And then maybe it's about the same at criminal history 2. 3 is a little bit higher. Okay. And then the issue becomes staff is saying, let's get rid of the 48-month enhancement. I agree, because why do we just have this one random thing in the guidelines? And then the question is, do we distinguish between adults and juvenile? And then here's what the distinction would look like if we did it that way.
Exactly.
Okay?
All right.
And then just one last question.
Sure.
Before you get to enhancements, the legislature has said it's worse for a juvenile than for an adult.
Right.
So this is consistent with that.
Yes.
But staff's recommendation is lose the 48-month enhancement, rank aggravated at B for adults, A for kids, consistent with the non-aggravated approach of
Right.
treating offenders who abuse kids more harshly.
Yeah, and I think taking the legislative rationale for that, making that distinction and saying, oh yeah, that makes sense, that's a valid distinction. It is more serious to abuse children than adults, so we're going to retain that in the sentencing guidelines. I think, which is what the sentencing guidelines do now. I think it's agreeing with the legislature's rationale for making the distinction and applying it to aggravated, which the legislature does not do.
And then as I look at this, even though there's a potential for a little bit of a sentence reduction, it looks like when you compare the 48-month approach to the adult enhancement ranked at B, it looks like there's a potential for a higher sentence within the range at every criminal history score, right?
It certainly looks that way from the chart.
Yeah. And the only time it goes down would be at criminal history score 0. And even though it's got a lower bottom range, it has a higher top range. So it's not really reducing it. There's like the potential of a reduced presumptive sentence. And then for criminal history score of 2, it looks like the midpoint's about the same, but it goes much higher. So I guess I've just satisfied myself that I'm not concerned that we're reducing a sentence by doing this. There is in theory the possibility of someone with a 0 criminal history would have a little more leeway in the range. Okay, this is useful. Thank you.
All right, we should probably move on because we have to get through discussion of all the other tasks. So I think that takes care of slide 4.
Is there anything else we need to do with sex offenders or sex traffickers, or is this it?
Yes.
I'm sorry, so there's,
This one's even
yeah.
just as bad,
So this,
honestly.
this one, well, I will just, you know, sometimes I'm a little too candid, but I'll be honest, I forgot about this issue until I was sending out the materials to you that you asked for at the end of the last meeting. And in reading those materials, I realized there were 2 issues that I said we'd get to later and we never got to. And this is one of them. Is sex trafficking a severe violent offense? So back in 2018, the commission created this thing called the severe violent offense modifier, which basically applies to somebody who's been previously convicted for a severe violent offense and then commits another severe violent offense. And they get an additional 12 months or more if they've committed multiple severe violent offenses. So it's a 12-month sentence enhancement for repeatedly committing a severe violent offense. The commission obviously was very selective in making this list. It's not a very long list. It's in your materials in this new document 2B4, but it's in one of the appendices. But it didn't clearly define the criteria by which it put the offenses on this list. This was, just to give you some context, the culmination of this very long criminal history review that the commission had done, and probably an even longer look at severe violent offenses. And the commission was really having trouble coming to some kind of consensus on this. And it kind of at the last second, everything came together into a grand consensus package that the entire commission unanimously, which is surprising given the makeup of the commission. And I know Commissioner Estrada was just joining the commission right about the time the consensus was coming together. And Commissioner Middlebrook was on the commission during that time. But the entire consensus came together at the end, and everybody voted for it. But this was one of the parts of the commission, sort of a trade-off for the criminal history reform was the creation of this severe violent offense modifier. As I said, they didn't articulate what the criteria were. This was pretty much a creation of Judge Schellhaus in consultation with Commissioner Champagne-Fromm, who is the victim representative, and in consultation later with Judge Lennon. And in listening to the meeting, the actual tape of the meeting, I listened to the tape of several meetings during that time. And I inferred that there were 3 criteria that the commission were using to define an offense as a severe violent offender. First, was the offense violent? Did the offense have an element of force, threat, or injury? That seemed to be something that all these offenses had in common. And it's in the name, severe violent offense. Second was severity. Was the offense above the disposition line? And this is something the commission talked about pretty specifically in response to a challenge that Commissioner Middlebrook had to some of the offenses that were below the disposition line. By disposition line, I mean the line above which everybody, regardless of criminal history score, is going to get a presumptive prison sentence, typically for at least 4 years. And some of the offenses were below the disposition line, and Commissioner Middlebrook pointed that out and said, "Are these really severe offenses if they're below the disposition line?" And the commission's response to that was pretty much, "Oh yeah, good point." And so they kind of seemed to accede to the idea that severity almost always meant above the disposition line. Now there was one exception, and that was the offense of second-degree assault resulting in substantial bodily harm, which is ranked identically to second-degree assault. Even though there's this additional element of the infliction of substantial bodily harm. And there was quite a bit of discussion at the time that maybe that's a misranking. Maybe second degree assault resulting in substantial bodily harm is a lot more serious than, you know, it could be anything from waving a knife at somebody to whatever. But if it actually results in substantial bodily harm, that's a different thing, and maybe that should be higher. And it was also pointed out that there was a pretty big gap at the time that was originally ranked between severity level 6 and severity level 7, which is now severity level 8. Since then, there's been an intermediate ranking, and maybe that's the appropriate ranking. The commission discussed that. They ultimately didn't resolve that question, but they did resolve to keep this offense, the second degree assault, resulting in substantial bodily harm, as opposed to second degree assault with no particular degree of bodily harm specified on the severe violent offense list. So that's the second criteria is that has to be met. And then the third criteria that also has to be met was, are there clear and strong public safety implications of repeat violations? So I got this from some of the things that members said, and I quoted them in the materials for you. But this included the requirement that the crime must involve an intentional choice to harm the victim. This was something that was repeated a few times by some of the proponents of the proposal, that these, you know, they said these are crimes where some, you know, the person was making an intentional choice to harm the victim. And then with sex offenses, and this wasn't necessarily articulated in the conversation, but a lot of sex offenses are not on the list, even though they are above the disposition line. And it seemed to be a thinking that the guidelines separately take care of repeat sex offenses. And I got a footnote in the materials if you want to look at that, but there are a lot of ways in which repeat sex offenders get hammered by the sentencing guidelines. And you get pretty quickly taken up to the statutory maximum. That has to do with weighting prior sex offenses. That has to do with the custody status point doubling for repeat sex offenses and so forth. So you move across the grid to the statutory maximum in pretty short order if you're going to repeatedly commit sex offenses. So that's what I inferred to be the criteria. So then we talk about whether sex trafficking is a severe violent offense. So look at the severity criterion. Yes, sex trafficking meets the severity criterion because it is above the disposition line. Lowest ranking is severity level C, which is above the disposition line. What about the violence criterion and the strong and public safety implications of repeat violations? And here's where I bring out this chart that has those aggravating circumstances. We just looked at the statute that has the aggravating circumstances on there. And I'm breaking it out in a different order than the statutory order. I'm breaking it out in the order that I think is most relevant to the severe violent offense inquiry. So the first aggravating circumstance that we're looking at is debt bondage or forced labor. So debt bondage, and by the way, it's not just any debt bondage or forced labor, which is true of labor trafficking. That's where those terms come from in labor trafficking. But it has to be for more than 6 months of debt bondage or forced labor. So that's a pretty big aggravating circumstance. And labor trafficking is on the list, right? So labor trafficking, which involves debt bondage or forced labor, is on the list. So that would seem to be a pretty strong candidate for putting on the severe violent offense list, sex trafficking involving debt bondage or forced labor. And so that would be option number one. We've listed 6 options for you. Option number one, if you just wanted to put that one on there because labor trafficking is on there, make it similar to the list, select option number one. Option number 2 also adds bodily harm. So that gets you, so option number 2 is probably the purest option in terms of being consistent with the existing severe violent offense list. It requires bodily harm, so that gets your violence element, no problem. And debt bondage, forced labor probably also is violent, especially when you're talking about the labor in question being sex acts. So yeah, that's pretty violent. So option 2 is pretty clearly severe violent offense too, in my opinion. Then you get into age, which age isn't always treated, in terms of crim sex offenses, isn't always treated as a severe violent offense. So if you get minor victims involved, but option number 3 includes minor victims. And then option number 4 is one of the more simple options. 4 and 6 are the simplest options. Option number 4 is just saying all aggravating sex trafficking offenses go on the list. And then option 5 is a hybrid of 3 and 4, where you're saying all aggravated offenses plus all minor offenses are on the list. I do have a footnote in the materials that points out a problem with option 4 and 5, which is you could be looking at quadruple or quintuple counting prior offenses. And here's why. So you've got the aggravating circumstances prior offenses, right? So this is somebody who's committed sex trafficking and then commits sex trafficking again. All right, so the person, it's an aggravating sex trafficking. So they've got that increase in their penalty because it's either the modifier or it's ranked higher because it's aggravated sex trafficking. Second, you got the sex trafficking in your criminal history score. So that increases the penalty, the prior. Third, you probably have a couple of custody status points from that prior sex trafficking in your criminal history score. Fourth, because it's on the sex offender grid, that criminal history score is magnified. It moves across to the right more quickly. And finally, fifth, it would be a severe violent offense. So you get 12 months more on top of that. So it seems like it's treating the same thing that you had this prior sex trafficking really severely under options 4 and 5. Option 6, as I said, is the most simple option. Well, options 4 and 6 are the most simple option. It just takes sex trafficking across the board and puts it on the severe violent offense list. Although, as I pointed out in text, you could argue that, sex trafficking, you'd have to basically take the position that all sex trafficking is inherently violent. But one could at least imagine a situation where somebody is, asks, somebody's involved in the sex trade and asks somebody to help them promote their business, and that promoter then is guilty of sex trafficking. Is that really a severe violent offense? So that's, you start drifting away, I think, as you go down the list from the original intent of the severe violent offense list.
All right, we have to go a little more quickly.
Okay.
So are there any questions on these potential options?
So it's not on the list now, the issue is, do we put it on the list?
Yes, I should have
And to
said
what
that.
extent?
And
As
that
a
was-
single option or not?
Yeah, there was a recommendation. So number 6 is the recommendation from CMHTTF. Just put sex trafficking on the list. And so this is trying to, and staff doesn't have a recommendation. I guess staff's recommendation was, you should at least put debt, bondage, forced labor, and probably bodily harm on the list. I think that would be staff's recommendation. But all of these are rational options. So we included them all as possible options that you might want to do.
Commissioner Larkin?
Examples of other things that are on the list, what are they?
If the list is in your packet.
Yeah, I'll have to pull it up. So.
And we really don't have a lot of time to go through it right now. We're going
Look
to
at
get to all these.
4A4, it's got all of that on there.
Yeah.
4A4.
4A4.
Page 20 has the complete list. So it's got the
Labor trafficking is on.
labor trafficking is on there, and it's almost bordering irrational to have labor trafficking on there and not have the aggravated sex trafficking involving forced labor and debt bondage off there. So option number 1, I think it's almost irrational not to do any of the options, and all of them are included in option 1. Option 2 also includes the force, which is very consistent with all these. So these are, I go into some detail about some of these elements, but.
All right. So think about it, ruminate on it.
But
Commissioner Larkin?
today, do we have to say, here's what we'd like to do? We got to vote next time? Where are we?
We would have to vote next time. So we have the options in front of us.
So
today.
all 6 of these options are, Madam Chair, for me.
Mhm.
All 6 of these options are on the table. And really the question is, for all of everything we've discussed today, is there anything different, anything in addition to these changes that we discussed related to sex trafficking that you want to discuss at today's meeting? And this is just sex trafficking. We still have to get through prostitution and custody status. But if there's anything other or different, we need to know that. And do you want any new research needed? So if there were a specific option that you're interested in us preparing estimates for, that would be really helpful to know at this point. And that wouldn't necessarily limit you on what you could do, but if you're like, oh, I like option 2, could you write that up? We could write it up. We could do an estimate for that. I don't necessarily want to have staff do all 6 options if none of those are live balls at this point. And again, this would not necessarily commit you to something in November, but it would be nice to know what you're thinking at this point, just so we could write it down.
We were directed to look at sex trafficking. Were we directed to look at putting prostitution? And what's the other thing we were going to talk? Well, custody point, that's a separate deal.
We were directed to look at sex trafficking.
All right.
No, but the proponents of the statute asked us to look at prostitution too.
Oh, it did? Oh, well,
Yeah,
but it wasn't in the legislation.
it wasn't in the legislation. I don't know why they didn't put it in the legislation since they wrote their legislation, but they made it clear that it was their intent and desire that the commission look at
Commissioner
prostitution as
Morath?
well, because that's some of their recommendations.
Commissioner Morath and then Middlebrook.
If we're interested in options, I personally was leaning toward 2 or 3. Same time, I won't go into rationale, but
Okay.
Thank you, that's helpful.
Commissioner Middlebrook?
I was gonna say the exact same thing if that would be something that would help for proposals.
And what's 2 or 3?
On his chart?
Yeah, two is the one that's sort of the pure option that just has debt, bondage, forced labor, or bodily harm.
Okay.
If those are present, and 3 is the same, but also with kids. With kind of the idea that if you're selling kids for sex, that's violent too.
Okay. I'm fine with that. And for what it's
Yeah,
worth,
I'd be willing to hone in on those 2 as well.
I'm fine with this. Going back to our rankings. I mean, I get that if, we were interpreting the statute, you go like plain language, they said both the same, but I think the fact that the legislature did distinguish between adults and kids, we have a rational basis to say, well, we're gonna continue to do that because I think it's worse with kids. And, just, we get a criminal history score of 0, that person gets the opportunity for a little lower sentence. Everywhere else, it goes up. So I'm okay with staff's proposal on the rankings as well. For what that's worth, because at some point, we need to vote on this. I know it's not today, but I would also say this.
Yeah.
If prostitution is not part of our mandate, it seems like we've got a lot of other work to do. Not that that's not important, and we couldn't look at that in our comprehensive review, but I think we should endeavor to at least address the specific things that were required of us.
All right, well, I'll try to go very quickly, Madam Chair.
Yeah, we are very tight on time and you're a little wordy today.
I'm sorry. All right, so the decision points so there's 2 prostitution offenses we're looking at. One is, as I said, we're calling using a minor for prostitution, if you're okay with that. The first question is, should these offenses be re-ranked on the sex offender grid? Everybody recommends yes on that. Staff, CMHGTF, and advocates for human rights all recommend yes on that. If so, where? There's a difference there. Staff's recommendation is to fit it at the statutory maximum, kind of consistent with how, and to do a nice stair step, consistent with how it's done. CMHGTF has a different ranking. I will note that one of those is more severe than staff's ranking, and one of them is less severe than staff's ranking. So B is more severe and F is less severe. And we agree on G. How about that? And then 3, should severity differ depending on whether a real child victim existed? So staff's recommendation is yes, rank cases that involve somebody believed to be a certain age differently than somebody who's actually that age, to reflect the difference in the lack of harm involved, because there's no harm if there's no victim. Culpability is the same, certainly, but the harm is dramatically different. And then CMH, TTF, and the Advocates for Human Rights both recommend ranking under the age of X the same as reasonably believed to be under the age of X because there's no difference in culpability or probably future dangerousness. Regarding patrons of prostitution, it's a little bit simpler. Should this offense be re-ranked on the sex offender grid? This does involve difficult questions of whether prostitutes are victims and so forth, and that's all discussed in the papers, but everybody recommends yes on that. If so, where? There's unanimity there to rank it as level G to fit statutory maximum. And then the final question, this is a new question, should this offense be eligible for permissive consecutive sentencing? And we just wrote up a new paper on that. But because all sex offenses are permissively consecutive, they're on that list in section 6. And if this is going to be ranked as a sex offense, then we think for coherence, yes, it should be ranked. It should be placed on the offense, the permissive consecutive sentencing eligible list. So the questions for today, are there any other or different guidelines, changes related to prostitution that the Commission wishes to discuss at today's meeting, and any new research that you'd like to see us do for November action?
Commissioner Larkin?
I think, because of time constraints, because of how heavy this is, we should simply say to the legislature, we've done what you've asked. We've addressed sex trafficking. If we vote on this, we've raised the potential penalties, which will make people happy. We think it's important to look at prostitution of minors, and we're going to do that next year. All focus groups are ongoing. I just feel like this one is too much for me to get my head around. And I know we've talked about it before, but I feel like, okay, I've got my head around the sex trafficking, but now this other issue is a whole lot of questions. Not saying don't do anything, but just maybe that's one we put off till next year.
All right, other comments? Does anyone else have a view on, I mean, I don't think we would do any additional work on prostitution. I mean, not meaning we wouldn't take it up. What I'm saying is, I don't know that there's any more analysis to do. So it is more about, are we at the point where we're ready to decide if we want to move either of these offenses over to the sex grid? That's the question.
And Madam Chair, not to disagree with you, I'm thinking when you say that, we could also do it in the spring and put it up for a public hearing in July. And
Yeah, and that's what I
just
mean. I'm not prepared to, for sex trafficking, I'm there. This is very useful. For this other 2-page list, I'm not there, so.
But I would just point out that there would be a meeting in November to discuss it. There would be a public hearing to ruminate on it, and then a January meeting to finally discuss it. So it's not like we're completely at the wire right now. So if in the next 4 weeks or so, you could just think about it some more and maybe you'd be ready by then, maybe you wouldn't, I don't know. But just bringing that up.
And what do other commission members think on this? I mean, do you want to try to move forward with this year? Commissioner Larkin?
And that's, if somebody would say, hey, I think we should do this and here's why, but if no one is saying that at this point, I don't know why we would expect it to be said in November. Could be wrong.
Commissioner Knudsen?
Well, on this area, I think there's a lot more agreement amongst the advocates, the Central Minnesota Committee, and staff. I think if we give it a month and take a good look at this and just review all the materials, I agree with Nate. I don't think there's any more analysis that needs to be done. It's just what decisions are we going to make? Then we can avoid in the future true public comment hearing and submitting the stuff to the legislature separately.
Okay. Well, I don't think there's any harm in having it on the agenda next month, and if we come back and we agree at that point that we're not ready to take a vote on it, then that's also fine. We can continue working on it. Commissioner Larkin?
In terms of procedure for any of these things we would vote on in November, does somebody have to put a motion before the commission and get it to Nate a week before, or no, because we've talked about it?
Yeah, this is,
Okay,
all
got
the
it.
stuff is here today.
That's,
Yep. He's just asking if we want any more analysis done for November that would help us make a decision, so that's why he wanted to know about severe violent offender ranking.
and the notion of treating cases differently depending on whether there was an actual child or it was a decoy, that comes from staff, not from,
It's just from staff.
and do we have that concept anywhere else in sentencing?
Theft takes other elements and differentiates based on amounts.
Well, that's amount.
I mean, I'm
as
just
opposed to-
saying, like,
Oh,
taking
no,
an
no, no.
element of the offense.
I'm sorry, do we have anything where we say, well,
Or, if I may, so ordinarily, by my legal analysis, I guess I still renew my bar license, I can say that. If a crime were committed, except for the fact that it wasn't a real crime, so, for example, well, I guess there is such a thing as purchasing fake controlled substances, but let's say that somebody were involved in an operation where there wasn't an actual crime at the end, some other kind of sting operation, that would typically be an attempt. So where somebody intended to commit a crime, but there wasn't really a crime there to commit. That would typically be an attempt, which the guidelines would treat as half the sentence. So there is, I think, that precedent that, and this is actually more severe than half the sentence. What the staff is recommending. It's recommending just ranking at one severity level below. But yeah, I think this would ordinarily be an attempt, which is treated less seriously. So there is.
and what's the crime? Solicitation?
Yeah. Well, the crime is using a child for prostitution. So having, paying to have sex with an underage child.
But we're dealing with circumstances where someone sets it up, but it doesn't happen because it turns out it's a police decoy waiting for you at the address.
Right. So there's no child there to have had sex with.
But the statutory language addresses that issue in that particular provision of the statute. So that's why it's not an attempt, because the element is the fact that whether it's I use this very loosely, a real victim versus the decoy, it's the intention of the person trying to do what they're not supposed to be doing in the first place is the focus of the particular crime. So the statute actually addresses that, and that's why it falls out, I think, out of the category of being an attempt, because the elements of the statutory language allows that to be something that would have to be proven.
Right.
For what it's worth, that part of the proposal is not appealing. Whether it's a decoy or an actual child, I think the punishment should be the same, especially if the statute's written in a way that says we're punishing the intent to do something. And I can't imagine, will you have an attempt to do an intent crime?
All right. Okay, so unless there's anything else on that, I think we could move on to custody status.
All right.
Before we do that, could you just tell me again, was it 4C we want to look at on this prostitution stuff, which?
So for the staff paper?
For the proposals from staff about how we would rank prostitution of a minor if we put it on the grid, which paper addresses that specifically?
4A3 is the issue paper, and then the text is 4D2.
4A3, 4D2.
And 4D2 does have, as I recall, alternative options for staff's option. So both of these are,
Okay.
There's language in there that we will assume you're voting on if you, depending on which option you pick.
And for C, has the impact of those different proposals.
All right. So we are moving on. All right, so this is custody status guidelines amendment. Again, there's no requirement to act today. The guidelines internal inconsistency regarding the treatment of one-half custody status point has existed since August of 2019, was identified in August of 2020, and was addressed by the Court of Appeals in 2021 and 2022. And 2022 was a precedential opinion, so it is, so that's settled law. So you could just continue on with this inconsistency in the guidelines versus what's actually happening. But if the commission wants to resolve the inconsistencies since August 2023, it must advance a proposal at the November meeting. And to do that, it must discuss the proposal or prior similar version of it at today's meeting or last month's meeting. So today's goal is to discuss all viable November options for resolving the inconsistency, if any. So what has the commission done? Just a quick recap. In October 2021, a few months after the problem was discovered, the commission advanced to a public hearing a proposal to change the guidelines surrounding rule, but ended up rejecting that proposal a few months later. November 2021, similar. They discussed a number of options, but advanced a proposal to repeal the entire custody status policy, but in January 2022, withdrew that proposal for further study in community, stakeholder, and legislative engagement and education. And in July 2022, the commission held a custody status roundtable, after which Commissioner Larkin proposed to codify essentially the guidelines, in the guidelines, the Bogdanovich opinion, so sort of to make status quo in the guidelines match up, which would disregard a partial custody status point when calculating the criminal history score. And since I wrote this slide, there's been a second proposal from Commissioner Larkin that would basically restore the full custody status point wherever it existed before, but have an opportunity for eliminating that custody status point for lower level felonies, provided that certain conditions were met. The impact of codifying Bogdanovich would be a 20-bed reduction, because the 3-month bump would also go away, which we're not assuming is necessarily true. It's not necessarily true in the status quo. So the questions to address today: are there any other or different guidelines changes related to custody status that the commission wishes to discuss? And does the commission wish to direct staff to provide any research needed for November action?
Great. Commissioner Larkin.
All right, well, as you can see, I have a new proposal, and thanks to Commissioner Ladd for reviewing it and pointing out that I made an error here, and I want to amend my proposal. Be short, because I know we're short on time. So, you know, my thinking was this: Bogdanovich is what it is. Is that what it is? Keep wanting to call it Bogdanovich because I'm from Illinois. Yes. In any event, my thought was, okay, the commission previously put a lot of work into coming to the conclusion that if you're on paper for a level 1 or 2 on the regular grid, or D1 or D2 on the drug grid, that's not worth the whole point. Let's make it a half point. So I was trying to respect that conclusion, that those probation on those low level offenses should not result in the same consequence as it would for a higher level offense. So what I propose we do is simply get rid of the half custody point altogether, go back to full custody points, but the rule would be you do not get that custody point if, so long as, let's make this more complicated than it needs to be. If you're on probation for a level 1 or 2 or D1 or D2 offense and you commit a new felony, or if you're on probation for a targeted misdemeanor, and that's what I left out. I should have included targeted misdemeanors in that paragraph. So if you're on probation for one of those categories of offenses, and you're not on probation as a result of a downward dispositional departure, which would always be the case if you're on probation for a targeted misdemeanor, because there are no departures for misdemeanor sentences. and your criminal history score is not 6 or more, then you don't get any custody point. It's just 0. But you would get the custody point if you're on probation as a result of a downward dispositional departure. So if it's, you're on probation for a level 1 offense, but it's whatever, your 5th one, they gave you a downward departure, so you're supposed to go to prison, you got another chance on probation, and you go out and get another offense, well, then you get your custody point. For misdemeanors, it would work, and you tell me if I'm right, because I've screwed this up before. You're on probation for a targeted misdemeanor, you get convicted of a felony, you would only end up getting a custody point counted towards your new felony if you're already at 6 or more. And in that circumstances, it's just going to be the 3-month addition. So it's a little bit of an extra consequence for people who are on probation for a targeted misdemeanor and commit a new felony, but they're only going to get the hit if they're already at 6. And I think people might argue that that's reasonable to give you an extra 3 months if you already have 6 criminal history points. It works like this: somebody's got 6 criminal history points, they're on probation for DWI, and they commit a felony. They get the custody point, which would just mean a 3-month addition to their sentence. So not all that bad, but sort of honors the notion that if you keep offending, at some point there's got to be an additional consequence. So that's what I would propose we consider at the next meeting, and I'll send this back out. Essentially, I would amend my proposal. So Nate, maybe you could do this, where the second paragraph where it says adopt a new role, et cetera, et cetera, et cetera, it would say, based on felony offense with severity ranking of 1 or 2 on the standard grid, or felony offense with severity ranking D1 or D2 on the drug offender list, or a targeted misdemeanor.
Can I ask a
Yeah.
clarifying question and make a plea?
Yeah.
All right, so the clarifying question, when you say targeted misdemeanor, are you also counting gross misdemeanor, non-traffic gross misdemeanors and gross misdemeanor DWIs?
Are those included? I would assume they
Yeah,
are.
those
Yeah.
are also, they were all in half point land.
Yeah,
basically.
so essentially I'm saying anything that was in half point land, just make it 0, so long as when we're looking at you, you're not on probation with a dispositional departure, and you're not at 6 or more on the grid.
So my plea is, I wonder if you would be willing to consider, instead of saying, was the prior offense a dispositional departure, if you'd be willing to just say, was the defendant's criminal history score 6 or more at the time of sentencing for the prior offense? And those would all be dispositional departures then? Well, I guess
No, not necessarily.
yeah,
No.
not necessarily, but,
No.
and, well, the problem is, that's a new data point that would add some work for probation officers and possibly invite error for sentences, but that's fine.
Yeah, and all I'm trying to do there is say, I mean, if a person was supposed to have been sent to prison, got a downward dispositional departure, and then commits a new felony, I think it's fair to say, yeah, that's where your custody status should matter.
It can take us up to like 18 months to figure out the complete, that information won't necessarily be available. That data point, was this sentence a departure from the guidelines, won't necessarily be something that's available to the probation officer who's completing the worksheet.
Why not?
Well, there are sentences that are done without worksheets. There are inadvertent departures. I mean, there can be, I don't know.
Oh, I see what you're saying. Well, I mean, if there is a downward dispositional departure, the court's supposed to acknowledge that on the record, make findings to support it, and file a departure report. That's why I'm questioning why we wouldn't know for any given case whether a person received a downward departure.
And we do eventually, but it takes a long time. We sometimes have to go back to courts multiple times to ask them for departure worksheets. And
But it
Yeah.
seems like you could also go in court records to find that out, just directly to the district court, right?
Yeah, but they don't always do what they're supposed to do. They don't always have a worksheet, they don't always follow the departure.
We have some-
Well, I'm just gonna, if I might, I'm gonna say, plug for my Todd Wood Community Corrections Group. I gotta tell you, every sentencing PSI I have, that's got a worksheet attached to it. It tells me in the little box whether they've got if they received a departure or not as part of the PSI process with the worksheet attached to it. That information is in every document. So they have it at sentencing. So I don't know where they're getting it, but they have it. And so that's a community corrections group. And I know we've got 3 different kind of probation folks in the state. So I don't know how that data comes again, back to our data issue, but I'm seeing it at sentencing.
And I guess the burden would fall on the prosecution. If the prosecution is saying, hey, this person should get a custody point because they had a downward departure, they need to go track down the records. It's just like saying, you need to go to Chicago and get the actual conviction offense so we can compare the elements to see where it lines up here. I mean, some of that just falls on the prosecution to establish.
I'm not disagreeing with that. I think on the back end for the electronic worksheet system, it would be very difficult to
Sure.
automate that. So it would probably end up being something that somebody had to figure out manually. Or, I just think it'd be really hard to automate it.
Unless we just used criminal history as sort of a proxy for, I mean, the problem is you could have somebody who has a lower criminal history score, but say had a firearm, a 5th degree controlled substance with a firearm, criminal history score of 3, and that's a presumptive commit. Is the probation officer going to know that was mitigated dispositional departure? I don't know.
I think we know. I mean, in all these revocation cases we see, it's like, they had a departure. I just don't think it's that hard to find out. And if they can't find it out, the person's not going to get the point. I don't think the default will be, well, we assume you had a dispositional departure, and therefore you get the point.
Right.
It would be on the state to prove.
Commissioner Estrada?
I would agree that the integrity of data being entered is not always the same, and I think in some of the smaller agencies, that's a lot more feasible. There are times where our pre-pleas or our pre-sentence investigations don't have that for several different reasons. The judge hasn't made a decision of how sentencing order might be, which can impact things. And sometimes, the guidelines is done after to Executive Director's Nate's report. It's not uncommon that we're getting the list from the guidelines, every couple months saying, hey, please do these, because we don't have that information. And then I think that goes to that other point. I do have a question. When I read this proposal and kind of the exceptions there, was there any look at the waiver option? And is there anything that contradicts them that would confuse practitioners in some of this?
The waiver option.
The waiver of the custody status point that's currently in the guidelines.
No, I didn't consider that at all.
I don't see any incompatibility. If under this proposal, there wouldn't be any points to waive.
Unless
Unless there were, and then it could be waived. I mean,
And then
even
it could be
somebody,
waived, yeah.
even somebody with a criminal history score of 6, I think you could waive the 3-month
Extra
bump
3 months,
basically
yeah.
if the waiver criteria were met.
And I appreciate the data and how we know, but I think the bottom line is at the end of the day, if the state is saying, hey, this person should be getting a custody point because this was a downward departure, and it's not reflected in the records, and the state has to go out and get a sentencing transcript or some sort of information to demonstrate that that in fact was the case, and it would have to be a finding by the district court at sentencing to justify it. I mean, what I'm saying is I don't think this all falls on the shoulders of the probation department. I mean, I'm not saying, well, the probation department has to come to the court and let the court know this, because again, when we're dealing with out-of-state convictions and how do they compare, there's all kinds of problems, but at the end of the day, the burden is on the state to come in and prove it up, if in fact, that's what they're asking the district court to do.
So the one The one question that I have is, so the way that this is structured, it's really focusing on what the current offense of the person is. Because you're saying if they're currently at D1 or D2 or severity level 1 or 2, that this is when you wouldn't count the custody status?
I'm saying if you're on
Custody.
probation for a 1 or 2 or a D1 or D2 offense and commit a new felony, right now you would get a half point because isn't the custody point based on the offense for which
Yeah.
you are on probation?
Right.
So I'm still using that as what determines whether or not you get a custody point and just saying instead of making it a half point, it's either 0 or a 1. It's 1 if you got a downward dispositional departure or you're already at 6, or it's 0 if those things are not the case. Neither of those exist. So it doesn't matter, what your new offense is. What guides it is what you're on probation for, which is, I understand it, and I could be wrong, is what guides it now. We don't say, well, your custody point is determined by the seriousness of the offense you're being sentenced for. It's based on what you're on probation for.
Yes.
Okay.
So I'll just be frank that to me, your proposal does raise a very good point in differentiating at the far end of the grid, right? With the very constant repeat offender. And that is also a concern that we've heard from public, although I think the public input we've received has been more focused on repeat violent offending rather than repeat nonviolent offending. But I think repeat offending in general is a concern of the public. And it's also a concern I have. And so where I get a little twisted is, what is the best way to address repeat offending under our guidelines? And custody status is the way that we've done it in the past. And I'm just still not sure if custody status is the way to do it in the future. And I'm not to make your fears come true, but I am a little concerned about doing more with this issue right now. If we're going to look more holistically at the guidelines, only because when we were at NASC, I saw that on some of the other grids, there's another way to deal with repeat offending, and that is, some other systems have another column that just adds months for certain types of repeat offending. And I keep playing around with that idea in my head, is like, maybe that's a better approach than to be putting this into the criminal history score, but that feels like a bigger project to me than we can do in a month. So that's why I have not proposed something like that. But that's what I keep thinking, is maybe we need to look at look at repeat offending on its own and sort of figure out what's the best way to deal with it. Repeat offending looks different for nonviolent and violent offenders. How do we address that? And so I really do appreciate you bringing up additional ideas here, but I'm not sure if this gets at it for me either at this stage. I don't know. Oh, Commissioner Moore.
Thank you, Chair. I don't see this as a zero-sum game situation. I think there's a lot of ways that we could go at the question of repeat violent offenses. I think what Commissioner Larkin's trying to do is to take this one half-point issue off the table, which has been, I think, just a kind of a burr in the saddle for too long.
Right.
But we've talked about things like the presumptive consecutive list, your idea of the grid, those are things that I think absolutely merit action. But kind of like what I was saying before, it's not let the get in the way of the good here. If we've got a proposal here that takes care of this one messy kind of, inappropriate thing, and I really think the point that's made in this memo about the Court of Appeals not being a policy court, I think that's a that's a very important point, that we took a temporary action to give some interim guidance, but to have permanent reliance on a non-precedential decision for the Court of Appeals, it is a presidential, is a presidential, but it just seems like it's, that's not where we want to end up here. So I mean, I would advocate moving forward on this proposal, but considering, the ideas that you're talking about too.
Commissioner Estrada and then Middlebrook and Knudsen, are you wanting to jump into?
Yes, please.
So we'll do Commissioner Estrada, then Commissioner Middlebrook, and then Commissioner Knudsen.
My only fear is different proposals that we've been talking along the way. We've had the data, we've had the demographics, we've had the impact on prison beds, we've had the impact on disparities. This is a new proposal without having any of that data, which we just had a conversation about prostitution, which we've been talking about forever as well, and postponing that. And what I'm hearing from the executive director is that it's not likely that we're going to get that data in a month. And so that's where I give pause, is that everything else that we've talked about on our this topic, we've pulled some of that data to be able to look at what the potential impact might be. And with this proposal, we don't have that data. So I fear kind of voting on this without knowing what that impact might be.
Could we get that for November?
I think so. Yeah, I think so. I mean, I think we should get the data. I'll tell you my concern really is implementation. I mean, this is a change that would make the guidelines more complicated. Just because it's a new way of calculating criminal history. It's not, but we can analyze the data.
Okay, let's go to Commissioner Middlebrook.
I guess I just have thank you, Madam Chair. I have a question for Commissioner Larkin. Did I understand you right that you're including both the targeted misdemeanors and any of the gross misdemeanors?
Yes, anything that was a half point. That was my intent. Anything that we currently assign a half point to.
Okay.
Got it?
Yeah, I guess my one other question is, and I have to think this through, but you're only using it for the, yeah, never mind. I got to think this through myself, because I'm just looking at some of the other areas on the grid in the shaded area, trying to figure out how that would work for those other areas, other severity levels.
Commissioner Knudsen.
Oh, there we go. Well, at some point we got to make a decision, and it seems like it's got to be next month. And the practitioners and the legal community are looking for us to resolve this matter. I'm just wondering, Nate said, well, it's going to be a different way of calculating criminal history. Well, anything we do on this issue is going to be a different way of calculating criminal history. So my question is, are there any other proposals that we will be considering next month other than the elimination of the custody status point?
We don't actually have that on the table right now as a potential proposal.
We don't have what?
Director Wright.
Madam Chair,
What don't we have on the table?
I think all we have on the table right now, from my understanding, is the two Larkin proposals and the status quo.
Okay. So that's what we'll be deciding then next month.
Unless somebody would like to discuss something right now.
Commissioner Larkin.
I'm just feeling a little frustrated because at the round table, we all went around the room and said, here's what we want to do. And the chair encouraged us to bring proposals forward. And I said, just, we got to be honest here. The majority still has a vote to go with eliminating custody status point altogether. And the majority indicated at that meeting that that's what it would do. And so I said, we need a proposal from the majority, because the majority has the votes to just say, do away with custody status point. And they're not proposing that, and they're not proposing anything else. And I've proposed half-point grids, incorporate the Court of Appeals opinion, and now spin on that. And so we keep being told, you know, you must bring proposals to the table. And we bring them, and it's like, no, and now it's like, well, we maybe shouldn't do that because we're going to do a comprehensive review. I'm done. I don't know what else to do. I feel like it's been clearly communicated to me at this point, don't bother, because there's an agenda. That's the train that's left the station. There'll be no more proposals from Larkin.
Commissioner Middlebrook?
Thank you, Madam Chair. I guess, I'm one that was in favor of eliminating the custody status point, but I was, trying to see if we could figure out something that worked for everybody. One of the things that came up, and I'll just put this out there, that came up on the presentation by Washington and Pennsylvania is a possible grid that goes on the side. I'm kind of fascinated with that, but I know we don't have enough time between now and next month to really pursue that. But it seems like that maybe that is something to look at, which is part of the reason that, I appreciate your proposal, Commissioner Larkin. I just have some concerns about it, particularly with these other areas of, other areas on the grid that are still low-level offenses that we see a lot of dispositional departures in some of those areas, and I guess that's where I'm kind of hung up on. But I think that there are some other options that we haven't pursued because it just came up.
Well,
And
why
I'd
have we
like to
heard
get
those options since last month?
Can I finish? I would like to get more information from those two states, or to see, how they're using those side grids for their custody status, or what they're using them for. I didn't have time between last meeting and this meeting to go look through that all myself. So I guess that's why I'm fascinated with it. I'm kind of interested if that would be something that would work, and we would, graduate some of that for the repeat offenders, getting higher up as you go higher. I don't, but that's kind of where I'm at with it, just so you know my position on it.
I would echo that, and it's just that time is our enemy right now. Unfortunately, we're at this point where a different idea that seems to make more sense came up, but it's not. It just was at a point where we couldn't have worked it up adequately for this year, especially considering that it would be a pretty big change to how we do the guidelines.
Is that idea much different than the one we considered in our small work group and presented last year at this time, where we would just have a certain enhancement based on custody status, a certain number of months added to the sentence? Isn't that one of the things that was presented and we voted them and it didn't get any traction? I thought we looked at that last year this time.
Probably, it's probably somewhat similar, but not the same.
It just seems to me that the end game here is elimination of the custody point. And if that's the end game, you've got the votes, do it.
Right now, I'm more inclined to follow the Bogdanovich ruling, which does not eliminate custody status for everybody on the grid. Any other comments or discussion?
Madam Chair, I have a comment.
Yes.
Actually, it's an announcement. If any members of the public, so in a little bit, we're going to have a public comment portion. If you are listening to this meeting remotely and there are no members of the public here in person, please raise your hand on WebEx. Please try to take some time and find how to raise your hand on WebEx and raise your hand. Thank you.
Okay, so, and one question I have for you, Commissioner Larkin, does this new proposal supersede your old proposal, or what's your intent for November? What would you like to bring forward, or do you want to bring this forward?
I'll let you know a week before the meeting.
All right. All right, Director Wrights, is there anything else that you need to cover today?
For the Executive Director's Report, yeah, so I just want to let you know, because it does affect you, I'll be taking vacation for 2 weeks shortly before the meeting in celebration of 30 years of marriage and recovering from 27 and a half years of raising children. So, you'll probably be dealing with other members of the staff during that time. Apologize for that. And that's that'll do for now.
All right, public comment then?
All right. If there are any members of the public who wish to make a comment, please raise your hand. And staff, if you could just raise your hand so I can see that you can do that. Yeah, it looks like you can. So I don't see any members of the public on the meeting who are interested in making a public comment, Madam Chair.
All right, then that closes the public comment portion of the meeting. I think we've covered everything on the agenda. And if so, then we will be adjourned until November.
Thank you, guys.